So good afternoon to distinguished speakers, esteemed colleagues and dear participants. It's my great pleasure to welcome you all on today's online session on intellectual property rights, management in universities, hosted by the Confederation of Indian Private Universities. CIPU is a not-for-profit membership-driven platform committed to strengthening the voice, visibility, and value of private universities in India. We work to foster the academic excellence, policy advocacy, and the institutional collaboration by connecting through the leaders from academia, industry, and the government. In today's knowledge-driven economy, universities are not only the centers of education, but also hubs of innovation, research, intellectual output. As institutions increasingly contribute to cutting-edge discoveries and technological advancement, the need for effective intellectual property rights management becomes critically important. So let me start with the session speaker, Adv Ravi Bhardwaj. So Ravi Bhardwaj is a seasonal legal professional and entrepreneur with over 2 decades of experience as a lawyer, renowned for his expertise in education and startup law frameworks. As the founder of EduLegaL and Startup Legal, he has dedicated his career to providing specialized legal solutions to educational institutes and startups. A law graduate from the prestigious Symbiosis, Ravi Aji has built an impressive clientele that includes esteemed institutes such as Symbiosis International, which is a deemed university, Symbiosis Skill Professional University, MIT World Peace University, Gokhale Institute of Politics and Economics, Presidency University, Savita University, Avantika University, Swarnim Startup University, and many more. With more than 20 years of rich experience, Ravi ji has mastered the art of delivering targeted legal counsel to universities, policymakers, and stakeholders in the education sector through EduLegaL, enabling them to navigate complex legal challenges effectively. As a startup legal, he provides essential services such as incorporation, intellectual property advisory, contract drafting, fundraising, compliances, and dispute resolution, contributing significantly to the development of thriving startup ecosystem. His dedication to mentoring startup and guiding educational institutions reflects in unwavering commitment to fostering the entrepreneurship and the education, particularly in regions like Bihar, where his efforts underscore his passion for societal progress. In addition to his legal practice, Ravi Ji is actively involved in promoting entrepreneurship on a global scale. He is a charter member of TIE Pune and TIE Patna, part of the global recognized TIE, the Indus Entrepreneurs, organization dedicated to supporting and mentoring the entrepreneurs worldwide. Furthermore, he serves on the global committee of TIE U, a specialized wing of TIE focus on nurturing entrepreneurship within the universities and higher educational institutions. Ravi's extensive experience, leadership roles, and impactful contribution position he as a key figure in the realm of education, law, and entrepreneurial ecosystem. Warm welcome to Advocate Ravi ji, our distinguished speaker for the day, and thank you for accepting our invitation and being here. So for next 1 hour, we'll be listening to him. In case of if you have any questions or at the end of the session, if you have time, we can take few questions. Participants can pose the questions in the chat box or simply they can raise their hands. From here, we can unmute you. And thank you so much, everyone, for joining. And over to Advocate Ravi Bhardwaj.
So first of all, very big thank you to CIPU to give me this forum. I am highly obliged to speak before our August audience, and I must congratulate the work which CIPU is doing under the leadership of my dear friend Mr. Karthik and obviously stewardship of Mr. Akshay. You are doing a wonderful job. Many of us might have met during the last conference at Hyderabad, where we had a very 2 excellent days of deliberation on very different facets of higher education. And we will possibly be meeting again in Chennai, I believe, on 12th of August, if I'm not wrong.
Yes.
It has really been a great experience working with you all. And I'm very obliged by the fact that I can contribute something to this growing higher education ecosystem. So, friends, today's topic, as Akshay already announced, is how do we manage IPR in educational institutions? Akshay, you'll be playing the slides or?
Sure.
You have to possibly do a slideshow because the left is interfering. Yes. So this is our topic, friends, today, that how do we manage IPR in education. Now, IPR is not obviously a new term known to either of the, faculties or vice chancellors or registrars who are there. And certainly not recently because of the quotient which it has been provided by different bodies of accreditation, which will travel when we go to our presentation by NAC and IRF. Because IPR has been given quite a substantial, indicator in these ranking systems. So next. Akshay ji, next. Before we proceed further now, why I have posted these two images. I mean, we resonate with these two in almost every day in our life. Google is not unknown to many people in this world. In fact, very profoundly, when we get confused, we say, "Bhai Google, bhaiya se pooch lo" types. So Google is something which you all know, and to tell you profoundly, Google was born at the Stanford campus, especially it's the page ranking mechanism, which we know as SEO. Many people work on the SEO of their website and all that. So Google was, born on the Stanford campus. And those, though it was an old company then, but the headphone system which has emerged very, you can find everybody with the headphones these days. That noise cancellation technology which has evolved now and which has become a kind of the order of the day was a collaboration between MIT in US and the Bose company. So why I have presented these two pictures to start with, friends, because we should know that when the institutions and industry collaborate, when institutions decide to innovate, they can really give to the world something which they never had, and something which has become the part of their entire life. These days we hardly see people without headphones, without noise cancellation technology, without SEO, without Google. So this is how an IPR can actually change the entire journey of an ecosystem. So that is why I presented these two, and this is how we will lead the entire discussion forward. Next. So now, having seen both the examples, what exactly is an IPR? Obviously we find two three. It's a combination of two three words, friends. One is intellect. That is one. Then it's a property. Property, we all know. We have flats, we have motor vehicles, we have this, we have that. So it's not different from any other property which all of us possess. But the only quotient which gets added, we have jumped it.
Sorry, sir.
So the only quotient which gets it's pre-qualified is that this property is basically germinated to an intellect. So, suppose if you are going to buy any other, property that do not require too much of, intellectual input. Obviously, it requires business decision, other research. But this form of this property basically comes through intellect. इसको हम हिंदी में बौद्धिक संपदा भी बोलते हैं, because ये बुद्धि से आती है, therefore it is called as बौद्धिक संपदा. And therefore, a property which finds its preface and preamble in intellect is basically called intellectual property. So what is basically, it's all innovation. Why it is innovation? Because it was not prevalent, it was not known until the particular time that it was brought onto the earth. It was brought into the reality. Therefore, it is an innovation. All other forms of property which you will possibly found may be existing somewhere in some form or the other. But intellectual property is basically innovative nature because it never came into existence until an intellectual person or a person with his intellect applied his mind and created this. What does it do? As I said, give the example of the noise technology of the Bose and Google SEO ranking system. It becomes an asset. Therefore, intellectual property is basically something which is very innovative, and it basically creates an asset. That's the most important two cornerstones of the intellectual property. Next. Now, so how, when we talk of basically property nature, we create something of our own. We put our intellect, we put our effort, we put our, labor, money, everything. So what does this intellectual property give to a person, give to a university, give to a student, give to a faculty? It's basically, if you see, I have made it bold in the second sentence, it gives you an exclusive right. What is exclusivity? Basically, that if you create something on your own, if you have done some drawing on your own, if you have patented something on your own, if you have done some design rights of your own, then it gives you exclusivity. Now, exclusivity would mean that anybody else other than you, or if you are owning with somebody else, he will not be able to copy it, he will not be able to reproduce it, use it in a manner which is not known to you without your permission. So that is what the basic facet of an intellectual property is exclusivity. Otherwise, this would have no meaning. We'll put so much of labor, money, time, energy, and if I don't get exclusivity, if it is open for everybody to copy around, then we don't get anything. Therefore, the facet which is important for us to understand going further is that not only you create something innovative, but you also create something exclusive for you. And that is what it makes this property very, very important and very, very integral. Next. Now, I don't think this needs much introduction, but just for the introduction of people who may be new to this subject of the IPR, there are very different kind of forms, like like in we see other properties. There are flats, there are vacant land, there are row house, there are bungalows. So अलग-अलग किस्म के properties होते हैं. So insofar as this IPR is also concerned, there are different categories are there. One is somebody is trying to speak, Mr. Akshay. This. So there is there are patents which I believe many of them.
Yes, sir.
There's a patent which is there. Then there's a copyright which is there. The trademark. We'll go into short examples of all these things when we move further. There are the industrial designs, which is a very unique concept that you all should know. And trade secrets are there, which we know more in terms of educational institutions as confidential information. Trade secrets are basically the confidential informations which we have. And when we move further, then we'll go into how all these different types of intellectual property relate to the educational institutions. Next. Now, first, obviously, when it comes to IPR, the most common IPR which is known to our educational institution is patents. Now, what exactly is patent? Patent is basically, it grants you, we need some processes to create some unique technology, or that particular technology itself. When we create it, we try to create exclusivity over it, and then when we apply it to a particular office, the right that we get is basically called as a patent. Now, what we need to understand here is this: all these forms of intellectual property are different in their shape and character. Trademark may be only by form of an appearance. Patent is exactly opposite to it. Patent is not only in form of appearance, but patent is exactly in form of a particular format. There are some hardwares involved, there are some softwares involved, there is some machine which is involved, there is an output which happens. Therefore, patent is basically a real-time living objects which are basically processed in a manner to create something unique. At this point of time, I must also point out, many of my, educational friends come to me and say that I want to, patent a software. Now, friends, please remember that software per se is not patentable. Software or algorithm or the AI codes that we use basically come as a part of the copyright and they are not patentable. So, when educational institutions, they want to drive their students, they should also know that the software codes that we develop are basically not patentable, but are basically copyrightable. In fact, in 2021, when I go to next, I'll also explain in detail. The patent rules were amended, and the patent rules were amended to the effect that the 80% of the fees which is charged for registration of the patent was reduced for the educational institutions. And in fact, many of you have visited US, UK, you'll see that patent is a very cornerstone of any university, especially in the cases of applied sciences. Especially if you see our universities itself, IITs do a lot of, great work in, creating patents and registering patents. So patent is one form of intellectual property right, which we'll discuss much later. Next. Now, copyrights, again, it is very similar in nature to trademark, but it exists in a form which it can be appreciated. Now, you can read something, you can draw something, and you can appreciate it something. Your articles, your source codes, your probably your exit forms, probably your course syllabus, or everything becomes part of a copyright. So copyright is basically a literary work, I mean literature that we produce during the course of our study or of our any project, or it may be kind of those who are into some graphic arts courses or graphic art institutes. It may be kind of a paintings. It may also be, as I explained to you, computer software is also is basically a form of a copyright. Now, there's a very famous case law which I have mentioned at the bottom, which you all can see. It's University of Oxford versus Rameswari Photocopy Services. I'll just take 2 minute pause to explain what happened in this and how it relates to educational institution. Friends, there's a very small photocopy shop near South Campus of North Campus of a Delhi city. Some of them who belong to the part of the North India. That photocopy shop, what he was doing is basically, or probably the students, they were trying, they took some different chapters from different authors, and they made a compilation for the purpose of the benefit of the students. And they used to photocopy it, and then they used to read it and appear in the examinations. And then suddenly Oxford University found that, people are not buying their books, but they're going and taking a photocopy of that, different sets with their seniors or their faculty have prepared, which is kept to add, not only this photocopier, many photocopiers around in that campus. And then Oxford University went and filed a copyright infringement case. The case had a long checkered history. But there's an exception in the copyright law, which you all should know, that if a copyright is put to a fair use, and if a copyright is, if any copyrightable material is used by any faculty to give instructions to its student, then it does not amount to violation of a copyright. It's a very long judgment. It's good enough to have a full one session on the judgment. But what this basically law was let down in his friends that, if there's some teaching material which may be, written by a particular author, part of a particular book, which is also a subject matter of a copyright. But if some extract of those books are made part of different compilations and are put to fair use by a teacher to teach his students or to give them some knowledge as a value addition, then does not amount to a copyright infringement. So we should be aware of this also when we move further. But I have found that many of our faculty and students who write articles, submit to journals. Now journals have become a huge hype these days because the indexation happens. The APIs are, the APIs of the faculty, how much articles you have written, where they have been published. All those have become quite hype in higher education these days. And therefore, it is very important to understand that what exactly is copyright. It also gives exclusivity, but always please remember that a copyright per se, even though it gives exclusivity, there are many exceptions when the use of a particular copyright is for a fair purpose. It does not have any commercial, indications, and it is for the purpose of adding knowledge to a particular class by a teacher. Next. I think this is the most common form of intellectual property that we know, trademark. When any logo that you see, any brand that you see is basically a trademark. Though it is called as trademark, friends, but when we practice this particular segment of law, one part is divided into goods and one part is divided into services. So, even though educational services or the educational institution do not come within the definition of the trade, as we know, we are basically, education is, known as a noble service, non-profit service, which is quite antonym to the word trade. But the act is called trade. But when it comes into practice, the act distinguishes the different kind of marks in two different primary categories. One is the class of goods or products, and one is class of services. And then education is one of the services which gets protected by the Trademark Act. And the most common thing that we find these days, and there are ample of instances which has happened. Many of you must have faced that also in your own education institution, that your logo gets copied by another logo, and full-fledged educational institutions are being run. And but the law prohibits it. As if you go back to my first slide, why law prohibits is, my dear friends, is that the moment you get your logo registered in a particular manner, then you get exclusivity over that particular logo. Otherwise, what would happen? Anybody somebody from Amity might be here right now. Anybody who starts Amity University logo, if there is no exclusivity, and then students staying, let's say, in Chhattisgarh, like some unauthorized campus of Amity University, he may believe that this is as good as any Amity in Noida, or as good as any MIT in Pune. Therefore, what this registration gives, it gives you the exclusivity to use it for your own purposes. If anybody uses it in a manner which is not authorized or not licensed by the particular proprietor or the owner, then that person is basically infringing your rights. And when the person infringes, then that means that you can file a case. Now, this also brings to me a very important question which I must dwell, but it is only for the legal understanding of the subject. I always recommend to my clients, the universities, that they should register as a trademark and copyright. But a pertinent question which comes to my mind and is whether registration itself is mandatory under the law, either of the trademark or of the copyright. The answer to this, my dear friends, is registration either of the trademark or of the copyright is not mandatory. Because what law recognizes is that you should have started or written or published in terms of the copyright at the first instance. The moment you have created a particular logo and put into the market the first instance, or written an article and put into article in a published manner the first instance, you get a prior right. So even though, suppose, let us say you start an institution, you use a particular logo, you might not have registered it. I'm just creating a hypothetical situation for you to understand why I'm saying that it is not mandatory. That you do not register your logo, but you start using your institution by, let's say, ABC University. Other fellow goes, does the trademark search, and you see that no, fine, this university is not used, it's not registered, but it has now gained popularity. So, on the presumption that it is not registered, he starts using the name for a university which is a fake university. In fact, now UGC these days announces a huge list of fake universities. You all must be knowing it also as well. So what happens in this case is this particular ABC University, which has started the university first, but unfortunately not registered it, he tries to go and files a case in a particular forum before a district court, that is the jurisdiction, saying that the other university is copying my name. Now, in that case, the next university which is using the same copy for this thing, he says that I am registered, you are unregistered. But the law will bar him to take that defense because the registration, though for the purpose of prima facie existence, it may give some exclusivity, but his case will be defeated on the ground of prior use. So prior use, therefore, when we always advise clients that the moment you have created something unique, start using it, start publishing it. Because until and unless that particular thing goes in public domain, then it is, it doesn't become, because the intellectual property, when we talk of rights have two basic concepts. One is right in rem and one is right in personam. Now, right in rem, friends, basically means that right against the whole world. And right in personam basically means my right against, let's say, Mr. Akshay Chaudhary. So that is right in personam. But right in rem would mean right against the whole world. So intellectual property is one facet, like my flat. My flat is right against a particular individual. But intellectual property is one facet of right, friends, which is right in rem. it is right against the entire world, even though you might have only registered it, but nobody else in the world has the right to go and challenge your right. Unless there's some, suppose unless you have not used it, there are other exceptions to it. Therefore, the moment you make it known to the public, you have make it known to the world that I own it, and therefore your right is as against the whole world. That exactly it is called as right in rem. And IP is one facet which enjoys right in rem. There are many case laws involved. Very famous case law happened of Doon School. Dehradun has a very famous old Doon School, and realizing its popularity, somebody tried to start Doon School in Srinagar. Then the dispute happened, and the other Doon School, which was not the actual Doon School, they were infringed from using the mark Doon School, because the other Doon School were not only prior user, but they're also registrants for that particular trademark. So this is one frame. And I must also advise many my friends who are here. Many times I've seen educational institutions just registering their logo only in form of trademark and for a particular class. As I said, trademark is into different goods in similar. You should not only register your logo only as a trademark, but you should also register also as a copyright. I'll dwell into these topics much later. And also, when you're registering your logo, don't register only as a one particular class of educational institution. Also register for a stationery, because many times you use your logo in stationery, many times you use it on websites. So all those forms are there. So try to register in different class so that it gives you universal protection. Next. Now, trade secrets, as I said, is basically a kind of a confidential information. Many times what happens is we create a unique cause, and confidential information is basically we find is very prevalent in employment contracts. I'll come to that later. So the unique syllabus that we create, is your confidential, because it leads to a particular quality. We all try to be unique these days, so that because there's so much wild rush of educational institutions, which are propelling these days, that everybody wants to be unique, and that uniqueness. I've given the example of Coca-Cola. We all know this is a very grand example, and we all know that they have a particular some formula which they put in their drink that nobody still knows till that, and that gives you a unique taste, and that is why it became famous earlier in the West and now in the East also. Another brand which was contemporary to them, that Campa Cola, is again now coming back into in India, as we know that talk is going on right now. So it's that uniqueness which you create in any kind of any work, that particular thing that may not be copyrightable. Please understand why it is confidential information, because that may not exactly be copyrightable, that may not exactly be patentable, that may not exactly be part of any other form of copyright, but that is something which is unique to you. And that unique, see, these are residuary classes. What happens is, when law is made, law is made considering, let's say, a particular fact in a situation, that something will fit good into A, something will fit good into B, something will fit good into C. But there is something which is left, which law thinks may possibly develop later, because law is dynamic, which law also thinks that possibly it cannot contemplate all these situations right now. And therefore, there's a residuary registration which happens. And that is exactly what anything that you have created unique, which possibly may not fit into trademark, copyright, patent, whatever, would possibly fit into confidential information. And that is why these trade secrets or confidential information are also part of the intellectual property, and they are also protected. In fact, the jurisprudence have developed very widely insofar as confidential information concerned, insofar as the course syllabus is concerned, in Singapore jurisprudence, and also in West. Next. Now, industrial designs. Now, this is also another form of a copyright. And basically, there are many design courses these days. And when we talk of innovation these days, we talk of design thinking. Design thinking is very important part of the innovation. In fact, there are many master classes which are held on design thinking. So design is also, friends, a kind of intellectual property. In fact, there's a specific, in fact, in India, it developed much later. In our first law, so far as designs are concerned, happened only in the year 2000. I mean, when especially it was, in fact, many of you who are involved in teaching IPR, there was a TRIPS agreement which happened, which kind of tried to, harmonize the trade relationships. When we talk of all this tariff war, which is happening these days, all were basically, have the germane in the TRIPS agreement. And that one of the important aspects of the TRIPS was that not only we should try to promote intellectual property, but we also try to, give a, affirmative forums, give an encouraging forum to protect different kind of intellectual property. And that is why Designs Act was made into being. In fact, I've not dealt into this, but we all should know that the semiconductor thing, which is very hyped these days, and our Prime Minister, Mr. Modi, is putting too much of emphasis in semiconductor these days. There is also a specific act for it, Semiconductor Design and Layout Act. I think that is also of 2000. All have germane in the in TRIPS. So all these forms of different intellectual property were now tried to be protected, regulated, and tried to be encouraged to give exclusivity to different legislations. Next. Now, when we talk of the properties, a question comes to our mind that what is the use of these properties? Because, something I am putting time, energy, labor, and if it is not giving me anything, then why should I get indulged into all these things? When I talk of the, physical situation of property, tangible situation of property, and for you all to know, IP is an intangible property. Suppose if I own any property, I own a flat, a motorcycle, or share, or stock, then I can trade in it. I can trade in it and I can make profit. Basically, then it means that I can monetize that particular property. And it is this facet which is also available in IPR. What are the different type of monetization that we can do with IPR? Licensing is the first most effective, way of IPR. We use Microsoft day in and day out. We use Adobe day in and day out. We use antiviruses day in and day out. All these are basically IPRs owned by different companies, which license to different individuals, and we pay for those licenses. Because when you go and buy an antivirus, when you go and buy a Office license or Office 365 these days, or OneDrive these days, or PDF का license हम लोग लेते हैं. So all these are, license mechanism by which, and that is what has made Bill Gates the most richest person in the world, that he created that particular IPR. And possibly, other than the people who believe in using the open source model of Linux and other thing, everybody possibly uses Microsoft Office, and that is why I'm the richest person in the world. So licensing is one of the most common form of gaining or monetizing the IPR. It's also selling IP. Many times you create an IP, you scale it up. Talks were on, I think, some 2-3 years back, that the Bisleri, the Bisleri brand itself, apart from its assets, was worth more than 3 crore rupees because of the sheer market that it basically it controlled. So also you can sell IP. So, then in that case, the ownership transfer, there's startups which are, very, almost every university and institutions which are here with us right now, I believe must be having their own incubation centers where they must be, encouraging startup, promoting startups. So startups also, these IP also help those startups, and these startups also create some kind of an IP. So that is how, and if the startups are able to create some good IP out of their own, innovation or coding they do, then they possibly attract investment, and that investment gives them a boost to operationalize their own this thing and scale up their businesses. So that is how we, we can also monetize this IPR, and it's this ability basically to get itself monetized that it has made it one of the most important property these days. Anything that you create an app, it's an IPR. You create a website, that is an IPR. You create something kind of any coding which can create multiple websites. That's everything is an IPR these days. You can't just imagine a life without an IPR these days. But importantly, it is that all those things are good enough to be commercially exploited and give you some good handsome money. That is why it's become important, because money ultimately, friends, right, wrong, good, bad, ugly, is the biggest motivation. So if that property is not able to give you any kind of a motivation, then this property is of no good. And that is why, it's important to understand that if you are creating an IPR, it is just not a hollow paper. It will monetize. It will give you some good resources, some good financial freedom. Next. So now that we have, captured the basic aspects of what IPRs are, basically, we'll start now focusing into how IPR, if you any of you have questions, you can keep writing the questions so my team can work on those questions and we'll address it as and when my session gets ended. So, instead of putting all the questions in the end, and keep giving the questions so that my team can start working on it, because it's a long topic and it's a long. Though I wanted to keep it short. Karthik here requested that I should try to make comprehensive, but this topic is so wide that and I thought I'll try to share whatever I have. So now, how IPR friends matter for us? I also work from education institutions. You are from educational institutions. So it's a matter of it's innovation tool. Like I gave example of Google. I gave example of noise cancellation technology. It's basically when you indulge yourself, when you involve yourself in this entire ecosystem, you try to innovate. And innovation can be any form. Recently I was speaking at a EdTech conference where there are many edtech startups were there, and we just gave them different problem situations for the students, and they came out with a very brilliant idea. And that is how the entire concept of hackathon has come. Then we have under the Ministry of Innovation these days, we have smart hackathons, software hackathons, different things. So it's basically it gives you a tool to innovate yourself, ask the students to create those innovation tools, and once you innovate, basically then you try to accelerate your growth, you try to accelerate your path. That is how it is very, very important. It puts faculty and students into a research culture, because to create anything innovative, you have to do a lot of research. You have to do a lot of market research, you have to do a lot of study, you have to do a lot of assembling, you have to do a lot of testing. So what it basically does is, it puts a lot of, impetus on the students and the faculty who are involved in a particular project to do a lot of research. So it basically drives the research culture in an educational institution. Obviously, it gives you lots of, the moment you can come with something innovative, it builds your ranking. And as I dealt in the earlier slide, it enables monetization. So that is how the basic, when you talk of IPR and related to the educational institutions, this is basically what we see. Next. Now, what are the common outputs? The question which has been asked, possibly this slide may answer right now. What are the common outputs in the institutions that we see? Research publications, whatever we do, maybe published anywhere, maybe in any kind of a journal. All these basically are part of the research publications. Again, these softwares which all the incubators which are there, they try to work on some coding. These are also IP innovations which you do, your logo, your possibly your trademark, the courses that you develop, the MOOC is now also talked about a lot. With the 60-40 component is being spoken, that 60 can be regular and 40 can be done from the MOOC courses. So all those things that we talk about, there are many other examples of copyright, of IP. Like, in one case I was arguing, then in fact I went in to argue that the exit form which an employee signs, or basically they can also be part of my copyright, because my exit form, which is unique to one of my client, it was basically quite unique in terms of questionnaire and response mechanism. So I'm trying to argue a case before a court that the exit form is also a matter of my copyright. So copyright, intellectual property basically exists in every facet. To say that we can differentiate it. The people, the presentation which I'm making for them right now, faculty makes presentations and they deliver it to the students, is also a matter of, but yes, there are certain exceptions which I dealt with in that photocopier case. Those are also there. But in an institution, everything that possibly we try to do is in some or the other form of a copyright. Next. Now, there are many, as I said, post trips, almost all the sovereigns in this world have tried to, promote IPR in different methods. We have arisen quite late for some reason or the other, but we are also doing a lot of work. Government of India has taken a lot of initiatives to promote IPR in many institutions. All of you must be aware of what I am showing right now. But there's a NEPOM, then there's a recently IP Utsav also has started. Then there's when Mr. Kalam was in name of Mr. Kalam, there's a Kalam project for IP literacy and awareness. Our Honorable Ex-President. Then there's a patent center is also there, which is called TFAC. They basically facilitate the processing and filing of the patents. And there's the intellectual property promotion scheme, SIP schemes also there. So many of the institutes who want to start at this level, who feel that they may not have resources enough to promote or protect IPR in their institution, should take benefit of all this. And there are quite good funds which come from these projects, and should try to take benefit from these projects and try to protect and promote IPR in the institutions. Next. Now, as I said, that is the government thing that is happening. Now, what has government also done, my dear friends, is that whatever they want to do does not remain only on paper. So what they have tried to do is they have tried to build incentive to promote IP in the educational institutions. And what they have done is that they have added the IPR policy, innovation policy, how much patent you have, your institution able to achieve, and how you promote innovation in university, all in the different ranking parameters. And how these ranking parameters function these days. If you want to open an off-campus, if you want to open a university, if you want to do an ODL course, an online course, all these rankings have become very, very important. And what has government done in a manner, we can say it's a kind of a compulsive, promotion of a particular stream. But sometimes, we need to take those steps so that, we can move from compulsory to free zone after at some point of time. Because we all should admit, and it's nothing wrong to admit in this forum, that our institutions, and many of them, are not very, effective and encouraging promoting IPR in their campuses. So therefore, they were built in the NAC parameter. I think the indicator 3, I think, if I'm not wrong, in the NAC and NRF also, it carries quite a lot of weightage. And many of the institutions who look for global ranking like Times Higher Education and QS ranking, they're also the institutions impetus on trademark and copyright gives a lot of weight to the ranking. So rather, even not by choice but by compulsion, institutions are now being trained to promote and this encourage this IPR and innovative ecosystem in the institutions. Next. Now, when we basically think of promoting an IPR in our campuses, what is the first thing that we need to do, friends? First thing that we need to do is to have a effective policy. That does not mean that I'm trying to canvas or propagate a kind of a bureaucratic structure. But until and unless we have some kind of a white paper, as we say, or a policy document, as we say, then the path is not very clear before us. And sometimes, as we are being used to the bureaucratic ecosystem in our country, that path we find in a particular policy document. Good, bad, ugly, we should admit that our path for a particular project comes in a particular policy document. And that is why it is very, very important. In fact, I do not know how many institutions are here have a proper IPR policy, or if they have a proper IPR policy, how many different kind of issues are handled in the IPR policy. And Karthik ji has been very kind enough that we will, start a kind of after this outcome, we'll have, we'll try to create a model IPR policy for our educational institutions. And I must thank Karthik ji for that. We are in a phase to create a model IPR policy, in which two of my colleagues are working on it. So first thing that we should have is a proper institutional policy. And other than the policy, when we enter into other employment contracts, because many of our employees, when people come into employment, we do not give equal importance to IPR clause in those employment agreements, because many of these employees are working on some project which involve IP creation, which involve, when I say IP, different forms of IP. but those employment agreements are absolutely silent on what happens to IP created by those particular employee. And in silence of all those, lot of disputes get created. Then we should have a proper disclosure framework also. Many times what happens is student is working on some project. We do not know. I mean, हमने एक project दे दिया, he's working on it. And suddenly he feels that he has done something unique. But there is no disclosure framework in the institution. So, he's completely lost. What should you do with it? What he should disclose, he should not disclose, to whom he should disclose, and if disclose, then what happens thereafter? There is no policy guideline. Therefore, it is very, very important, friends, that we should have a proper disclosure framework within our institution, that once you feel that you have created something, it may not be patentable, it may not be registrable, may not be non-registrable. That is the job which is later to be assessed. But what is important is the moment you feel that you have tried to create something unique, you make a mandatory disclosure to your faculty in charge, to supervisor. So that framework has to be very, very important in education institutions. And once you have done it, I'll come to the later part also, that how should revenue sharing be done. Then one of the important aspect that how you should incentivize all these things is you should enter into, you have created something unique, you feel you can monetize it, students were working, faculty were working, then the question comes is, should then institution own everything? Should then institution receive every money from that is generated? Like, for example, my colleague has given me an example, like IIT Madras invented a standing wheelchair. Standing wheels was invented, and all the students and faculty who were involved, when that it was licensed later, everybody got part of the royalty. So that is what that is why you need a policy for this. And this also, ensures that there is no conflict between people who are working in the same project. Otherwise, what would happen? He would feel that he has done it, C would feel that C has done it, and everybody will do whatever they want to do. In absence of policy, all these conflicts will keep happening. Therefore, it's very much important that not only there should be a proper IPR policy, there has to be a proper incorporation of such policy in different documents, which we'll discuss later. Next. I think we are already down 45 minutes. Actually, I still some, I think. Now, I have dealt with this in the previous slide, but the IP policy should basically, deal with, you should cover the, objectives very clearly, what kind of, IPR that you are looking at. Because if you are not an engineering college, then obviously not looking much at patents, you're looking more at copyright and things like that. And the most common form of IP that we look in education is obviously patents. Then, as I said, disclosure process to be very clearly defined. There has to be ownership clarity in that policy. Then how it is monetized, and how the revenue has to be shared. So these 4 or 5 elements are very, very important to put in an IPR policy. Next. Now, when we talk of commercial, I did deal with this when I was dealing it generally, but just, as a backdrop, that when we want to commercially exploit an IP, what should be the things we should be running in our background? Like, first thing which comes to our mind, and I gave the examples of many things that we have hackathons these days. Hackathons are what basically an idea is thrown into the market. And the students are asked to work on this project. But then at the time that we know, when ideas are thrown out and ideas are chosen, and you feel that the student has to work on that particular project, at that stage, if you can possibly try to assess the commercial value of that particular project, that would be very, very good for institution, because then in that case, there would be a kind of a clear picture that once this project is done, once this project is over, that this is the way that it would be commercially exploited. So that is one aspect that you should think in the very beginning. What are our needs? Like, I tell you, I was in a meeting the other day, like these days, and one of my clients is developing the project. One of, one registrar came to me and said, कि sir, हम लोग को बहुत सारे undertaking sign कराने पड़ते हैं. I have to send on email, I have to get on email, then I have to record it. So basically they said, can we develop something on it? Then I asked one of my clients, she's based in Goa. She said, we can develop something around it. So now we are trying to automate the entire process of, a student, an undertaking being sent to a student signing that particular undertaking, parent signing that undertaking, then stamp paper being affixed into it, then the document gets notarized, and then it automatically goes and gets stored in a particular database. So that is, because, otherwise it is so much of a, cumbersome work that an undertaking of student, and they have to sign student undertaking, they have to sign anti-ragging, they have to sign POS, ye, wo, 100 undertakings student is made to sign. But then can we make that process easier? Yes, we can do that. And that is what the relevance that you have to see when you start thinking of an IPR in the in your campus. Other things which we have already dealt with, so I will not deal more. We have seen into how the revenue can be created and how IP success stories can help in ranking accreditations. Next. Now, when you see that a particular thing has come up before you, because as I said that if a property gets created, it is important that that property is protected also, because if you do not ensure an adequate protection for it, registration, as I would repeat again, is may not be mandatory, but yes, you need to take certain steps to ensure that the property is protected in a particular manner. Like suppose you get a patent, you feel that a student had developed a patent, then you should ensure that a proper filing happens. Government of India has a dedicated facilitation center to help students in filing the patents. Many of maybe availing their services, many of you may not be availing the services, but that is very, very important to know. You should get something copyrighted. Many times you publish the journal, you publish an article, but you don't get it copyrighted. And all these processes, friends, we understand are cumbersome these days, but I must tell you, and I vouch for it, very, very easy these days. Apart from patent and designs, copyright is completely an online process, complete online process. You just need to fill an online form. You just need to submit the work that you have done, the article that you have written, and within 5 to earlier, the registration used to take 5-6 years. Nowadays, you get a certificate within a matter of 5-6 months. So in these awarenesses, until you take all these steps, even though you are creating an IPR, but you're not protecting an IPR. Please remember, friends, IPR is not only about creation or generation, it is also about protection. Similar thing happens about your trademark, you have done your logo, please protect it, please register it, please publish it. They are very, very important. Whenever you are entering into any discussion regarding any development of, you may have something in your mind and you want to, get a particular software developed, get a particular kind of, syllabus developed, enter into an NDA. NDA is one of the most basic document which I feel that every institution should sign when they are entering into a particular kind of arrangement with anything. We enter into ERP models, we enter into admission models, we enter into, course modules, but we don't enter into NDA. I do not understand the reason that why don't we enter into NDA? Because possibly they feel it is tasking, but it's a very short format. It's not long, but it will protect your idea so that your vendor does not talk to 100 other people. Your idea remains unique with you. Because if your idea is not unique with you, then you lose everything. And that is why, NDA is very, very, very important. And the moment you see that these things, and you have taken enough steps to protect, but it is not going the right way, it is being breached. Somebody is copying it, somebody is infringing it. Please use proper cease and desist mechanism, send them notices, file case against them. Because if you don't take steps to select, it's like the property. Suppose if you have property, and if you're not putting and you're not staying here, and you don't put proper, lock, door things, you are, making your property vulnerable. You take all those mechanisms for your own property. Similarly, you take those mechanisms for your intellectual property also. Because property will help you, will monetize, will add to you only when it is properly protected. And if there's a case of breach, then you take steps so that that breach is, breach is challenged. Otherwise, then you lose everything. Next. Now, when we, as I mentioned, when we talk of the, IPR policy, when you talk of project, there are very different kind of ownership models are there. When it is many times only university, projects develop a project, then only university is the owner. So depending on the contribution of different persons, different stakeholders, it may be university completely, it may be university and faculty, it may be faculty university together, it may be some sponsored research. These days we get a lot of sponsored projects also from other institutions.
So depending upon the contribution, which we get from, different kind of organization to create a particular IP, to work on a particular project, because every project in some or the other manner leads to question of an IP. So ownership basically has to be decided on. But what is important is, please read my last line at the presentation, is there has to be very clear documentation and MU. Understanding of ownership, understanding of ownership cannot only be oral. Understanding of ownership has to be particular, and I must fairly admit, having worked with many education institutions in this country, I find that the concept of ownership of IP is the least given importance in any agreement. Or if they are there, then it is so worded that it is capable of 100 other different kind of interpretations. We as we'll be trying to create a FAQ also and a model IPR process also for all of you, because it's very important that everything gets covered, because otherwise it may create a lot of disputes. Because again, I said, the moment you talk of ownership, you talk of monetization, and money is the biggest cause of dispute these days. So it all will create a lot of disputes. Next. Now, when you talk of students' rights in universities, I think PhD question had come, which I'll address later also. Then, how do generally universities work? If it is basically, if you have given some project, then how ownership should flow. Suppose if it is a part of a, thesis, like PhD thesis is there, things are there, then generally should vest with particular, the student or that particular supervisor. Institutions should try to get a credit on those publications. Then you have startups, you have campus incubators, different incubators and different policy to own the IPR. Many just are satisfied with 2% equity. Many say that in this IPR there was some kind of ownership. So different kind of students IPR also flows. But what is important is, again, is to that to encourage the innovation in the campus. Many times institutions actually feel that no, everything should be worked with us. Students are working in our campus, students are ours, we are giving them space, we are giving them money, so everything will belong to us. But then the question you should ask to yourself is, can such approach actually generate innovation? Can such approach actually encourage innovation? Friends, answer would be a big no in such cases. You need to share some revenues, because if student gets encouraged, if you feel that once I create this, if a faculty, like earlier when faculty used to do MDPs, even the entire MDP thing used to come in the kitty of the universities. That is what used to happen earlier. But lately, 5, 6, in fact, if you go to a decade, now universities have also started sharing MDP revenue with the faculty. Around 30-40% of whatever the earnings come from the MDP are sent to the faculty, because that acts as a motivation. So similarly, when you are trying to create an IP within or trying to promote an IP within the institution, do not try to possess everything of your own. It is important that you share with the students. It is important that you share with the faculties. When it is then only when you try to create that, promote that culture. Next. Now, I've dealt this aspect in detail earlier, but there are 6 important things that we need to follow, and this is one slide which possibly summarize what I have discussed earlier. Is how do you actually effectively manage an IP in an educational institutions? You first try to encourage IP creation through research, collaboration. Then you should also have a proper mechanism of disclosure. And once it is disclosed to you, then you should try to evaluate. There has to be a proper mechanism. Like in patent, we do prior art search. If somebody comes, then you try to do whether such patent already exists or no. Because if such patent exists, then there is futile to move further with the process. Therefore, there has to be a we evaluate, to do our due diligence, we search. It is also in trademark, we do a particular search. Then you take steps to protect. You file that IP. It may be copyright, patent, design, whatever it is. Like an example I give to you of National Institute of Design. they created a kind of a modular, furniture for their classes, and they found that it is, something very unique. That kind of furniture nobody had in the world. So they went and protected the design of that furniture. Can you believe it? They protected the design of that particular furniture. And when it gets protected, at stage of protection, friends, the next stage very importantly comes, which I'll do the next slide very importantly, is that's not enough. You have to try and put effort into it to say that once it is protected, other than it is purpose for your own use, you should try to monetize that technology. You should try to, pass on that technology to a particular industry. It may be MSME, it may be SME, it may be a small industry, it may be a big industry, but try to ensure that the particular technology gets used by a particular third party. And it is only when it gets used by a third party, other than your trademark and things like that, it's that stage that monetization, that commercialization of the IP will start. And once that starts, you have to also effectively monitor the use so that nobody else infringes it. Next. Next. Now, when we talk of basically patents, we talk of many of the, it's very prevalent term in Western world. TT offices are there, and basically when you talk of technology transfers, again, what are the different kinds of TT transfers which happens? It's not different from other technology transfers that other methods of IP monetization that I have discussed. Basically, we can license, we can enter into a research partnership. That's very, very important. We take a project together and then we work together on particular these things where I also bring back technology and other also brings technology, and together we create something innovative. So that is another form of technology transfer there. Then the technology which I have, I then try to pass on to my different incubators. That is also kind of technology transfer, which is very common form in incubation programs that many of the institutes run these days. And then is the PPP model. PPP model is very, very prevalent these days in our country. And a lot of the IITs which are functioning, they are doing many projects in the PPP. Many of the private universities, which are there, are also working many in the PPP model. And the technology which they have, they try to work with the government by taking grants or by taking help of some other departments and try to develop very unique technology. So that is how TT offices also have to, aid this development. Next. Now, how do we basically deal with IPR in contracts? We talked about IPI a lot, but when it comes to dealing with IPR, then how do we deal? Because, ultimately, as I said, documentation is very, very important. And when you talk of IPR, there are basically 2, 3, 4 things which are very, very important. We should necessarily talk of ownership, that once the IPR is developed, who would own it? If there are joint ownership, then what are the different kind of joint ownership right that we have? Do we have to take each other permission to use it? Can we use our own on our own? If we are using in our own without asking each other, then how do we control the quality? How do we ensure that technology is not diluted? Then suppose if I am licensing that technology to somebody, which happens in technology transfer offices, then what is the territory? If the territorial limitation is there, then if the license is there, then is there any limitation to the duration of the license, or is the license is for a particular form? So all those things have to be mentioned. If there is a revenue sharing is there, then the share percentage has to be written. And then what are the confidentiality obligations? Because it is the confidentiality thing which is very, very important, which protects your IPR. So when we are trying to, any contract that you deal with and you're dealing with IP, these are 4, 5 important things that you must necessarily consider when you're drafting an IPR contract. You all must be having your own legal cell or must be having your own lawyers also. These are very, very important things that you should deal with. Next. Now, as I mentioned, when you do the technology transfer, when you try to work on many projects, there are many IP issues which does arise. First thing, that when you try to work on 2 different institutions, then there's a confusion that who would own more IP, because it would depend. Somebody may bring in money, somebody may bring in manpower. It may have, and somebody else may bring something else. So it is this, when the cross institution, which when you are developing everything within your own institution, then that is fine. But it is when 2 institutions come together and try to collaborate, then the cross institutional collaboration try to create some difficulty. So that is the point where IP issues should be clarified very clearly. then when foreign universities come in, because what happens is IP law in India may be different from IP law somewhere abroad. So the creation of the IP, the protection of the IP, the labor of protection which is available to them may be different in different jurisdictions. So when foreign institutions and foreign funding gets involved, it is important that you have some knowledge about different IP regimes in different territories, because the difference of territorial applications and legislations may also create some problem. Many times what happens is we try to use an open source to create something proprietary of our own. The question comes is you never use your own brains, use the open source to create something unique. Then what happens to the outcome? I mean, since the means were open source, since the means were never copyrighted, since you never invested in those tools to create these things, then can you actually claim exclusivity? That is another issue which arises, and those all issues will get answered or are getting answered day by day. Then obviously this personal disputes of co-inventorship can always be there, where two people may think that I did more and he did more, and I should be paid more and he should be paid more. Those are basically kind of different personal disputes which are there. Next. Now, what are possibly the risk areas that that we say plagiarism? One of the most unfortunate thing which is happening these days and happening at a very rampant pace is plagiarism. So much so that UGC has made a full-fledged regulation and on how to tackle with the problem of plagiarism. In fact, uh, some 15-20 days back, friends, three of a very senior faculty of our client were terminated just because they indulged into plagiarism. So plagiarism is one thing which is a very a kind of a very big danger to the entire world of the IP regime. Many times we just submit our journals to we give an article to journals, and we sign on some dotted forms. Many times they are big journals. They'll ask you to submit your articles. You submit your articles, and in the end you just put a tick that I'm agreeing to these terms and conditions, and you don't know what you are putting a tick to. So basically, when you put a tick to, you are submitting all your copyrights to them. So these journals, these big journal houses also sometimes try to play a trick, because what happens is the faculty, the students, they don't know exactly what are their rights which come from the articles, what is the exclusivity that they have, how they can protect to. So all these, these are big risk. And I said in the end that there's a very poor level of documentation which happens. We do not document things, we do not write things, we don't try to make everything clear. And all these are big risk issues when we try to understand IPR creation and management in the education institutions. Next. I think I'll just try to flip quickly because hardly 20 minutes left for the question and answer session. We can just skip this, Akshayji.
Yes, sir.
We can go to the next slide.
Okay.
Because I don't want to. So, what are the best practices that we should do? We should try to develop. We should try to do capacity building of IPR in our institution. We should make a good, effective IPR policy which should be accessible. We should have an IPR cell. We should have an IPR coordinator, and we should try to take stock of what IP which we have created, how much value that is added, how innovative it is, how we can do commercial exploitation. So yeah, good some basic practices which we can do in our universities. Next. So these are basically some key takeaways. We should protect early to avoid the misuse. You should not only, as I said, creation of IP is just one part of it. Managing and enforcing is another part of it, because the creation is not enough. Because if you are not trying to enforce it, then other person may be wide large to just use it in a manner they want. Should have very clear contracts, so that there is no loss, there is no damage, there is no reputational harm, there are no disputes, and protect IP, which actually drives a real impact. Next. So thank you. This is what Mr. Akshay said in the beginning. In today's world, knowledge-driven economy, intellectual property is the foundation of academic excellence, institutional credibility, and obviously long-term impact, as Google is having every day in this world. So that's the impact that we create when we create IP in educational institutions. Next. Yes, we are a firm called EduLegaL, friends. We deal exclusively in educational domain, and that is why the name EduLegaL is. We are open to questions which I'll try to address and I'll try to answer. In fact, I think two questions are already there. Ms. Bharati Saikrupa has asked a question. A curriculum model developed as part of PhD research need to be patented or copyright. Ma'am, I was very clear, I think. See, if you, I do not know when you, when speaking a model here, are we talking of a model curriculum in terms of being written into A, B, C, D, or are talking of a model or a particular shape that you are creating? If you are there, you can unmute yourself. We'll have interaction. I'll try to answer your question. If it is exists in particular form in a black and white on a particular page, you can apply for a copyright. But if it has, it has developed in a particular kind of a model, as in a particular shape which is visible, which is identifiable, then it's not copyrightable. You need to go for a Designs Act. On the Designs Act, you have to basically apply. I think is that answer clear, Bharti ji? You can unmute. You can unmute our chair.
Yeah, sure.
So it's a model with context activities, then you can copyright it. It's not a shape. You can copyright it. Yes, Bharti.
Bharti ji, you can unmute yourself and you can ask your question.
Screenshot. Bharti ji, go ahead.
You're not audible, Bharti ji.
Hello.
Yes, Bharti ji, go ahead.
Yes, sir. Thank you so much, sir. Actually, I asked the question before you even explained about the patent.
Yeah, I saw that.
So, yeah, I got the answer. And there is another question from my side that I asked.
Yeah, please. What is your other question?
Sir, as you say, for the hackathon, I have presented an idea there, but that was just an idea. It could not be.
There is no right in an idea,
changed into
ma'am.
a-
Idea has no rights.
Idea has no rights. Okay. I see. That was just the question, because I put there an idea, but it could not be, changed into a product. But maybe later, after some years, if I could incorporate it into some technical things.
See, the
change it into
moment
an
you
app
give it
or
a
something.
shape, the moment you try to give it a shape, it will become protectable.
Okay.
Idea does not have a
Thanks.
copyright.
I see. Yeah, it's clear now.
Okay, thank you, Bharti ji.
Any other question, Bharti ji?
No, sir, not from my side.
Thank you very much for joining.
So I think someone, Aniket ji, is having some question. He has raised his hand. Aniket ji, you can unmute yourself.
Yes, I'm audible.
Yeah.
So my question is like, how can we, if actually I'm working as an assistant professor and I'm a EDIC coordinator, Entrepreneur Development Innovation Cell. So it's relevant to that, like how can we effectively integrate IPR awareness and protection mechanism into student led innovation and startup initiatives at the college level? So especially when many projects remain in the early prototype or ideation stage. So for that.
So basically, see, first thing that you need to do is you need to have a proper, startup policy or an incubation policy, correct? And
Yes.
that incubation policy should basically deal with that once, let's say, a student and a student A has identified itself with, let's say, idea A, then you should try to ensure that that particular idea remains only between him and you. That's the first
Okay.
thing that you should do. You should not spill over to somebody else. That's the first stage of protection that you should provide to the product. Otherwise, if it spills over from you to any other student, then a student will not be encouraged to share any idea with you.
Yes.
Answer number one. Second is, once you discuss that particular idea with the student and you find that it is capable of some kind of a form, it is capable of some kind of business augmentation, then you should try to assess it from a proper an IP professional, that is, can we go further and achieve a patent in it? Can we go further and achieve a design rights in it? Can we go further and achieve a semiconductor rights in it, like the chips and all that which people develop these days? So once you have an idea, before you feel that it is capable of some progression further, then you should put it to evaluation. And at every stage, Aniket ji, you have to ensure that these ideas remain only between him and you. Because the moment it should not spill over. And once you evaluate and you find that yes, it is capable, and the evaluator also finds that yes, it is capable of some kind of protection, please then go and try to give them a particular regulatory registration. So there are two, three steps that you should take, and then put it in innovation policy and try to ensure that it is implemented.
Yes, sir. Yes, sir. Yeah.
Otherwise, everything would be open to everybody there in that case. And if that requires signing an NDA, please have an NDA between you, the incubation center, and the student. Have a proper NDA in that case. There is no difficulty. So that
Okay,
we are bound. And student should also feel that yes, he can go and disclose any idea to you without any fear, because there's an NDA between Mr. Aniket and student B.
Okay. Yes, sir. Thank you,
We'll be
sir.
developing a kind of a template and we'll be circulating to all of you.
Sure, sir. Sure. Thank you.
Yeah, thank you, Aniket. So if anyone has any question, they can simply put it in chat box, or they can simply raise their hand also. Yeah, Sudhaji.
Hello.
Yes, Sudhaji, good evening.
Is it audible, sir?
Yeah, if you can be a bit more up in pitch,
Hello.
it would be more conducive.
Sudhaji, you
Hello,
can.
sir. Is it audible?
Yeah, go ahead.
Yeah. Sir, I'm an assistant professor in the Department of Nutrition and Dietetics in JSS AHER. My question
Hyderabad.
and my
Is it based
question
in
is,
Hyderabad?
no, sir, it is in Mysore, Karnataka.
Acha, Mysore. Okay, yeah, go ahead.
So since we are working on natural products like food formulation development and all, so we are doing some formulations. How can we go ahead for either patent or IPR of these products?
Patent, madam, patent.
Patent, sir.
So it will lead to a product, right?
Yes, sir.
Yeah, patent.
So since it is
See, a
from
patent
natural,
would go through a lot of stages, ma'am. You have to, first of all, draw some specifications, which you have to describe your formulation. You have to, write that how the way that it is unique, or if something else exists of same character earlier, then
okay,
how the thing that you are doing is adding novelty to the existing thing. So see, novelty can be of two kinds. One is absolute novelty, and secondly is novelty on something which is existing, which is called value addition, right? So you have to
okay,
do your specification, apply for it. You will get a provisional registration. Then it will go through the stage of examination, probably opposition. You may have to answer. They may ask some questions, and then possibly you may get patent in the end.
okay, sir. Okay. Since it was natural product sources, so I had a little doubt. So I.
No, even if it is natural product source, see, everything today in more or less form is a natural only, madam. But
Okay, sir.
the thing that you need to do is that natural thing, you are using your intellect to formulate in a particular manner to create something unique.
Yes, sir.
But if
Yes,
it
sir.
leads to something medicinal, then compulsory licensing regime is also there in patents. Huh? Like for some life-saving drugs, you cannot have unique patents because the new law is going to come.
Yes, sir. Yes, sir. Fine, sir. So this is like health foods we are preparing. So
No, we can have a detailed call through CIPU. Actually, you can arrange a detailed call with ma'am later, and then we may possibly guide her in a specific manner that, having understood, because we have developed a very good, AI-based model for patent registration for educational institutions, madam. So we can help you.
Ma'am,
Okay, sir.
you can simply drop us a mail or get in touch with us. We'll share the details of Adv Ravi Bhardwaj with you.
Sure, sir. Yeah.
Okay, thank you.
Thank you, sir. Thank you for the guidance.
Sir, we have one more question. So, Deepali ji. Deepali ji, you can unmute, yes.
Yeah, am I audible?
Yes, ma'am.
Yeah,
Good evening.
Good afternoon, sir. Sir,
Good afternoon.
yeah, first of all, thank you for the very nice presentation.
Thank you.
In between,
I thought there are many less questions. I was not good at it.
no, sir. Everything was so clear, crystal clear. So there were not many queries. But
That's the other way to That's the other way to compliment a person. Huh?
No, sir, I would like to ask one question. In between, I got disconnected because of some reason, but you gave a very nice example where you were talking about furniture design.
Yes.
It was done in a different way and unique way.
Yes,
I just
yes.
want to know under what category of IPR we can encash this.
There's the Industrial Designs Act, ma'am. There's the
Okay,
Industrial Designs Act of 2000.
okay,
You can apply for design rights under the Industrial Designs Act.
okay. And this comes under the patent category or
No, that is the confusion that everybody has, that
Oh,
everything comes under the patent.
okay,
That's the biggest confusion in the entire educational ecosystem, that
okay,
everything comes under patent. Designs is a separate act.
okay, okay, okay.
Designs is a separate act. If you want, through Akshayji and CIPU, we can have a session for you. I mean, we can
Sure,
discuss
sir.
it. Then there's a separate act called Industrial Designs Act of 2000, in which you can apply only for design rights.
Okay.
And
What is the
nobody
convenient
can
way?
copy your unique industrial design.
Okay. What is the convenient way I can drop a mail to you?
You can contact through Akshayji and CIPU.
Okay, sure. I'll drop a mail. Thank you.
Thank you.
Thank you so much.
Yes. So we have one more question from Dr. Nirmal. Yes, Dr. Nirmal, you can unmute yourself. Ma'am, you can unmute yourself and answer the question.
Hello.
Hadi ma'am, good evening.
Sorry, sir. Was in some discussion. Like, sir, I am Dean of Pharmacy College, sir, here in Maharashtra. Sir,
Yes, ma'am.
drafting patent is a difficult task. And then we do research. We people are good in research, but this drafting is such a difficult task. Sir, can you train my faculty for that?
Yes,
Can the
yes.
faculty do that? Or we should hire only agents?
No, see, if everybody wants to do everything, madam, then possibly half of the world will have to sleep at home. Okay. So sometimes, in our good olden days, which
Yeah.
unfortunately got perverted into a different system that we are living today, there was we had a one system, if you recall, division of labor, right?
Right.
Where the skills used to decide the individual. So, you should do the research and you should leave the drafting to a patent agent. Otherwise, how will patent agent earn his life? Anyway, that's on the that's on the lighter side of it. What we can do, Akshayji, I put it for your thought, and Karthik, I put your thought. We can have a separate, session on how to write specifications for patents, and we should, because if faculty gets empowered in the institution, then certainly it would aid a lot of, IPR creation. And ultimately, for the purpose of, doing some formalities, we can obviously hire a patent agent, because you need a patent agent, madam, there is no escape to that, actually, unfortunately. You need a patent agent to make your applications, okay? But we can have a full-fledged session and we can tell you how to write a particular specification. Yes, it is a bit complex. There is no doubt on that. We also spend some hours and hours, because you have to understand the entire technology. We have to understand every step of it. Every step has to be defined. Then the outcome has to be defined. Then how that outcome is unique. सब कुछ लिखना पड़ता है. It's almost like writing a thesis.
Yeah. Sir,
But I give a food for thought to CIPU, actually, to decide. We can keep a session on writing a specification on patents.
Sir, once we receive details from your side, MGM School of Pharmacy from Maharashtra will definitely write to you, sir. Thank you so much, sir.
You're more than welcome, ma'am.
Yeah.
Yeah, so I think in the chat box already, someone from your team has already uploaded the details. So participants can, copy these things.
Do you have any other questions?
No, sir, I think we don't have any more questions now. And time is also, we are up to the mark.
Yeah, so that's one beautiful thing of a session, that it can start on time and end on time.
Correct.
Then I think, though with less of questions, which I thought would have been more, but then, do share your, at least outcome of what you felt you
Sure.
you took from this session, and how we can contribute more. We CIPU as a forum, or me as a professional, how you can contribute more to your IP creation. Have a IPR policy, friends. Try to promote IP. Try to share things with faculty, students. It will go a long way. See how much West and have developed the IP regime. You think of a technology they develop. We are also catching up, but we generally are followers of what they are doing. But the beauty part of is, while following also we are excelling in it. So that's the beauty part of our country. Today we stand long and tall in the entire world, global ecosystem. So, but try to do, create more IP, try to generate more IP, encourage more IP. That is all that I'll tell you. That's my short and small message to all of you. You all can, interact with me later on LinkedIn, anywhere that you want, and certainly I will help you in whichever manner that you want.
Sir, maybe you can also announce the topic for our next.
Yeah. So while we were discussing this session, we thought that we'll work on 2-3 good projects for you. Keeping IP with us, like as explained in a project, you should have IP. If you're very clear about IP. One is we are trying to create a compilation of judgments which relate to the intellectual property and education institutions. These judgments will basically give an indication that if there are disputes, then what is the general law which courts takes into view. We'll also be creating a FAQ for different forms of intellectual property, like for trademark and copyright and patents. That is what we'll be doing. And third, we'll be creating a model IPR policy. And I also feel very happy to announce that 3 of my young friends are working on this project. Ms. Kirti, Mr. Dikshit, and Ms. Prasanna. There 3 people are working on this project. And very soon we'll come out with all these things.
And in coming time, we are also going to have one webinar.
Yes. Now, this webinar is my favorite webinar that I conduct for all of you. Since this is the starting of the academic session that we have, along with my friend Sumesh Anthony, I conduct a webinar on how to conduct the practice and procedure regarding the anti-ragging complaint. So that I'll be doing next probably next month, because that's one of the most important topics prescribed by the law also. It's necessary as we start our academic session that we should know that how ragging is to be first of all prevented, and if possibly cannot be, if complaint happens, then how it is to be dealt with. So that entire webinar will hold for shortly.
Thank you, sir. So as we come to the close of this insightful session, on behalf of Confederation of Indian Private Universities, I extend our heartfelt gratitude to our speaker for the day, Adv Ravi Bhardwaj, for sharing his valuable time, expertise, and perspectives on the evolving role of IPR management. Your contribution had truly enriched our understanding and inspired a new ways of thinking, sir. So thank you so much. And a big thank you for our participants also for your enthusiastic engagement, thoughtful questions, and for being a part of this important conversation. Yes. Thank you so much.
The best part, Akshayji, was that webinar started with around 60 people, and till then, if 50 to 53 were there.
Yes.
So if you have a continuing strength of around 90%, then you should at least pat yourself and say that you have done a good job.
Correct. Yes, right. And it will
Thank you. Thank you,
reach to a
friends.
wider audience through our recording and website. Yes.
Thank you.
Thank you so much, sir. Thank you so much.
Thank you.